Good morning, everyone. I'm Judge Colleen O'Brien, and I'm honored to be here today with my colleagues, Judge Kathleen Feeney and Judge Randy Wallace. This is the second day of our case call in Grand Rapids. I know that most of you are familiar with the Court of Appeals, but for those of you that are not, I want you to understand we have thoroughly reviewed all of your cases, your briefs. Some of the cases we've even had a chance to talk about already. So there's no need for you to go through the facts with us. Please just tell us why you believe you should prevail before the court today. Anything else that you feel is significant, and then we may have some questions for you. We may have some questions today cases today involving minors. And yes, we do. So if you have a case involving a minor, please do not mention the name, just use the initials, because these matters can be reviewed by the public later, and for privacy purposes, please just refer to the initials. All right, the first case today is docket number 14-368-486, People of the State of Michigan versus Michael John Robert Bertrand. Okay, we have
Good morning, Your Honor. Brett DeGroff, Your Honors. Brett DeGroff from the State Appellate Defender Office on behalf of Mr. Bertrand.
Thank you. You can proceed, and I will also acknowledge that we have a remote appearance from Ms. Davis on behalf of the appellee.
Good morning.
Good morning. I know Your Honors don't need an invitation, and I do have some remarks, but if Your Honors have questions, I would invite them at any time. Sham dismissals are a cynical tactic employed by the prosecution in this case and across Michigan. If the state and federal speedy trial rights are at all meaningful, this practice must be prohibited. I know Your Honors read the briefs thoroughly, and so I'm not just going to run through the factors. I do want to address, as I did in the reply brief, a couple cases cited by the prosecution. First, McDonald. They cite it for the proposition that these sort of sham dismissals are permissible. That's not what McDonald says. If you read the opinion, that was not a dismissal and immediate refiling, as happened to Mr. Bertrand, as the prosecution did to Mr. Bertrand. That was a case where the prosecution actually did dismiss the matter, and a different prosecutor picked up the matter years later. And there's a block quote on page 11 of our reply brief that explains why McDonald is different. In McDonald, the court talks about how that dismissal was a meaningful one because the defendant was out and free and going about their life. Of course, Mr. Bertrand was not. The prosecution also cites Colombo, another federal case, and for the proposition that sham dismissals are permissible. And again, Colombo actually assumes the very opposite. A short quote that I also put in the reply brief, Colombo says, indicating sham dismissals are not okay, quote, were it otherwise, the government would be able to nullify a defendant's speedy trial right by the simple expedient dismissing and re-indicting whenever speedy trial time was running out on its prosecution. And that's pages 23, 24 of that opinion and page 12 of our reply brief. And that is exactly what the prosecution did to Mr. Bertrand. In terms of the Michigan speedy trial right, the prosecution argues that the Michigan Supreme Court has held that Barker controls and it's the same as the federal right. That's not true. The Michigan Supreme Court has never held that Barker controls the Michigan constitutional right. The best case, I mean, ultimately this goes back to Grimmett, And Grimmett certainly did not hold that. As we discussed in our reply brief, the application in Grimmett did not mention the Michigan constitutional speedy trial right. The grant order did not mention the Michigan constitutional speedy trial right. The opinion does not mention Article 1, Section 20 of the Michigan Constitution, which contains the speedy trial right.
But don't you agree that the court did adopt the Barker standard for speedy trial in Grimmett?
No, I don't, Your Honor, because so if that were the case, so as again, the application didn't mention it, the grant order didn't mention it, the opinion didn't mention the Michigan Constitution. That opinion did talk about Michigan's double jeopardy protection. If you read that opinion and talking about Michigan's double jeopardy protection, not only does the opinion cite the Michigan Constitution, but it elaborates on it. So if you think that Grimmett adopted the Barker test for Michigan's speedy trial right, then what the Michigan Supreme Court did was answer that question when no litigant raised it, when the grant order didn't ask the litigants about it, when the opinion does not cite the Michigan constitutional provision that we're talking about, and just sort of waved its hands at it.
But then
That's not what Grimmett
But
says.
then how do you respond to the fact that in People versus Williams in 2006, the Supreme Court said that both the United States Constitution and Michigan Constitution guarantee the right to speedy trial, and courts balance the four factors, the Barker factors, to determine whether the defendant was deprived of his right to speedy trial under the Constitution?
Well, if Williams is saying that Grimmett adopted the Barker test for Michigan, then I think we should look at Grimmett, and Grimmett just didn't do that. I mean, we can read Grimmett and know that for ourselves. So I would invite the court to look at Grimmett and see if in fact Grimmett did that. It didn't. And when Collins,
Williams is wrong then?
I don't think Williams says that. And the prosecution has cited Collins for that same proposition. And Collins doesn't say that either. What Collins says is, if you look at it carefully, what Collins says is that Grimmett said that Barker, quote, is the present and definitive test in this area. And so what does this area mean? So, think about that carefully for a second. Collins doesn't say that Grimmett adopted the Barker test. Collins says that Grimmett said Barker is the definitive test in this area. So, of course, Barker itself could not say anything about the Michigan speedy trial right. We know that. The United States Supreme Court has no authority to interpret the Michigan Constitution. So Barker cannot control the Michigan speedy trial right. And to the extent that Collins says that Grimmett said that Barker determined this, Barker cannot answer this question.
Why not? I mean, we use federal rules in the Supreme Court's interpretation on a lot of different constitutional things. So I don't understand why Barker can't be the test.
Barker could be the test if the Michigan Supreme Court said it were so, and it has not.
But Judge Feeney just pointed to Williams though, where, and I'm going to quote, in Williams on page 250, it says, quote, "This court adopted the Barker standards for a speedy trial in Grimmett."
Okay, this court, being the Michigan Supreme Court, adopted the speedy trial test for Barker in Grimmett. Okay, so that could mean one of two things. That could mean that the Michigan Supreme Court was recognizing the Barker factors for the federal right, which it must, which it is bound to do, as is this court, for the federal test. Or it could mean that Grimmett adopted the Barker factors for the Michigan right, which is what the prosecution is saying and what I think your honors are asking me about. And if you want to know the answer, if that happened, then I would refer you to Grimmett itself, the opinion. And if you want to read deeper and ask if it was interpreting this, then I would invite you to look at the order, the grant order, which I've cited, and the pleadings, which I attached as an appendices to my reply brief. And if you look for yourselves, you can see that Grimmett did not do that. So if you want to make sense of Williams and know what Williams means, then there's an obvious answer that Williams is saying that Grimmett is adopting or employing or enacting the new federal case. And we say this all the time in the, there's an oft-cited case where, Michigan says we recognize Strickland. We recognize Dauber. The Michigan Supreme Court does this sort of thing all the time and makes clear that this is what we're doing in Michigan now. And I would say that that's what Williams was saying about Grimmett. Because if we look to Grimmett, it doesn't say that. There's no analysis. It doesn't even mention the provision in question. Happy to discuss that further, but if your honors have no more questions about speedy trial, I would like to briefly touch on the jail credit issue. Of course, this court is bound by IDZIAC, and we're preserving that issue for further appellate review. And that would pertain to all 506 days of Mr. Bertrand's detention. As to the second half, the period after the sham dismissal, there was no parole detainer in place. And so Allen controls and Mr. Bertrand is entitled to the credit.
But why wouldn't the same detainer apply? I mean, they're telling them, you just can't let them go. So the message on a detainer is not to the prosecutor or the court, it's to the sheriff. And so nothing has changed about the fact that he's on parole and they shouldn't let him go because he's allegedly violated his parole and they need to hang on to him. So where's the case that says every time that they dismiss and they might refile, they have to file a new detainer? Because I did not find that, and I don't think you cited it.
There's no case that says anything about it one way or the other, Your Honor.
But you're reading it as they have to file a new parole detainer, correct?
I'm reading Allen, which says whenever someone is held, a parole detainer must issue, and if a parole detainer does not issue, then the defendant is entitled to credit.
But he was on parole. He has a new offense. They filed first, they filed again. So where does it say that because they had one charge, they dismissed it, filed a new charge, that the parole detainer evaporates, goes away, he's not on parole anymore, and he somehow gets credit?
Your Honor, there is no case that says one way or the other about this.
But logically, I'm not following your argument, because how can you say that somehow once they dismiss the first charge, right, and they're going to recharge him, that he no longer is on parole and he somehow gets all that credit back, even though he's on parole, has new charges against him? Because that's what you're asking us to do.
Your Honor, if I might, I think that I have a two-part answer to your question, if I might. The first part is the prosecution's primary argument is that there is no case law that says exactly what I'm saying. And that's right. I acknowledge that. There is also no case law that says exactly what they're saying. There is no case law that says that when they do a sham dismissal, they don't need a new parole detainer. There's no case that says that either. I would invite your honors to ask the prosecution that question, and I don't think they have a case for you. So putting that aside, and if we agree that there is no case that says one way or the other, then I appreciate your honor is asking what sense does that make if they know the parole detainer is in place? And I think that the problem is that the whole situation with IDZIAC is incredibly complicated, and it spawns an endless iterations of new problems because the rule itself is unworkable. And I'm not asking this court to do anything about that. This court cannot, I understand, but this court does have to follow Allen. And Allen is one of those iterations of problems that spawn from IDZIAC. And what we know from Allen is, and so if we were to zoom out and proceed as if we did not have Allen's guidance, then a lot of the things your honor was saying might lead us to wonder, well, why do we have to wait for the parole detainer? If folks know that he's on parole, why would they let him out? And if that's true, then under IDZIAC, he just shouldn't get the credit. But that's not what Allen said. Allen says, full stop. there has to be a parole detainer in place.
It was.
Well, I would argue, so if there was, if it's all the same case, then this brings me back to the sham dismissal.
Oh, wait. Let's back up and look at the legal principle behind the detainer. So the reason we have the detainer, because it's possible that the individual has violated his or her parole, right?
Correct.
Why we're detaining them. Let's say in that situation, the person has their charges dismissed and they're not going to be refiled, right? Can the
Correct.
person still be found to have violated their parole?
They could.
Hypothetically, yeah, they could, right?
They could.
So,
But
they would still be detained anyway, even if the charges were never filed again until it was determined whether they violated their parole or not.
let
And
me,
they're not going to get, if they get charged with some new crime, while all that happens, let's say something totally unrelated, are they going to get credit for the time that they're being held on that detainer?
let's explore Your Honor's hypothetical a bit more, if I might. So suppose someone is detained, they're on parole, they're arrested, they're charged, and a parole detainer issues. The charge, and suppose there's a terrible mistake. They got the wrong person, right? And everyone agrees that, oh, they were looking for John Smith and they got his brother Jerry Smith. They never should have arrested Jerry in the first place. And so they dismissed the charges. If the parole detainer is still active, then poor Mr. Jerry Smith is sitting in jail doing dead time when everybody agrees he didn't do anything wrong.
But when was that determination made? That determination had to be made at some point in time, not just that they withdrew the charge, but there may be something else at foot. So there might be another charge underlying it. There still has to be a determination that somehow, oh, he didn't do this. So your example is a different situation than what we have here and that what Judge Wallace has presented.
Well, I think what we're trying to understand is the effect of the dismissal in this context.
Well, even in that context, he's going to be detained until the system figures out whether or not he's violated his parole, right? They're not just going to instantly let him go the second his charges are dismissed on this case where he was wrongfully prosecuted, right? I mean, there's a procedure
I
in
would
in
hope he- I
effect.
would hope he
It could
would
happen
be.
pretty quickly, but they're two different things. The dismissal and the decision that you have not violated your parole, those are two distinct, different decisions, are they not?
Well, the parole violation, I'm
Because
sorry,
there's a
I'm
million-
sorry, I started
Because
thinking and
there's
I
a
missed the
million
end of your
reasons why they
question.
could determine someone violated their parole, right? Not just that charge. There could have been circumstances underlying that charge that are deemed to be a parole violation. The charge and the decision on whether or not the individual has violated their parole, those are two different issues.
Correct.
Right.
But the detainer itself is not the parole violation decision. What the parole detainer is for is it says, because of the new case. The parole detainer says, because of the new case, hold on to that person so we can make a later decision about parole violation. There doesn't need to be some sort of parole violation acquittal for a wrongfully detained parolee to go free. They just, if the reason for their detention is another case, if that case is dismissed, they should go free. Absolutely.
Regardless, it's still two different decisions. I would hope we could all agree on that.
I do not agree on that.
So you think that the decision with regard to whether or not they violated the parole is the exact same as the issue of whether they're being charged in this other case? Those are the same.
Those are, no.
They're precisely the same according to you.
No, that's not what I said, Your Honor. And I think what I'm saying is whether or not they violated parole is also not a decision made by the parole detainer. A parole detainer is issued by an administrative person in the MDOC somewhere. That's not a determination about whether or not they violated parole. And the revocation of a parole detainer is also not a determination about whether someone has violated parole. The only function of a parole detainer it's an administrative document that's transmitted from one department to another to say, we might want to make that determination at a later time. And if the reason a parole detainer issues, as in Mr. Bertrand's case, and I think in most cases, is because of charges on a new case, when that resolves, the parole detainer also resolves. And your Honor's asking if that's some sort of affirmative adjudication that parole has not been violated. It's not. I'm not claiming that. But you don't need, in the state of Michigan and in the United States of America, you don't need an affirmative determination that you haven't done something wrong to be freed from prison. And so if someone's arrested and the prosecution admits they should not have been, and if that arrest is the sole ground to detain them, when that charge is dismissed, the parole detainer should be inactive.
It's not the sole reason to detain them. The reason you're detaining them is because they're on parole in the first place, and there's some question as to whether they violated it or not.
Yes.
You're trying to replace this individual like this is the first crime they've ever been charged with. I don't mean the individual in our case and talk about in the hypothetical case. And that's not true. We're talking about somebody that's on parole to begin with.
That's true.
Anyway,
and he still has the constitutional rights of, he still has except for perhaps whatever Fourth Amendment rights he's signed away as a part of a parole agreement, he still is entitled to the full panoply of constitutional rights that all Americans are.
Yeah, nobody here has said otherwise, but I didn't mean to sidetrack you. Go ahead.
I think I've answered your Honor's question.
Yeah, no, I know. That's what I was saying. Go ahead on your next argument.
That's my last argument. If your Honor have no other questions, I'll save the balance of my time for rebuttal.
Thank you.
All right, Ms. Davis.
May it please the court, my name is Jasmine Davis, Assistant Attorney General, appearing on behalf of the people. This court should affirm Michael Bertrand's convictions and sentences for second-degree home invasion, false report of a felony, and malicious destruction of a building. The first thing that I want to address is opposing counsel's contention that this was a sham dismissal. This was absolutely not a sham dismissal. I wanted to draw the court's attention to, it's in the appellate file, but the trial prosecutor himself filed a motion for reconsideration on January 3rd, 2023 in the trial court in response to the trial court's imposition of sanctions. And therein, he explains what caused the delay between because as you know, on the record, there was a delay between when the October 21st and October 24th reports came in requesting confirmatory analysis and the need for an additional biological sample. And then it wasn't until December 2nd that the search warrant for the additional buccal swab of Mr. Bertrand was issued. In that motion for reconsideration, the prosecutor explains, and as he explained to me when I spoke to him, yes, the reports came in on October 21st and 24th, but he was in back-to-back trials. And it wasn't actually until around Thanksgiving that he saw those October reports saying, hey, we need an additional biological sample. And then from there, by December 2nd, he had the search warrant issued. He did have to perform a little bit of research to just see what exactly was required in case law, but it wasn't as if he got these reports in on October 21st and October 24th and then waited, 5 or 6 weeks as opposing counsel puts in their brief and just rested on it to intentionally delay Mr. Bertrand's trial. There was nothing intentional about the prosecutor's actions in that regard. At most, it was an oversight, which does happen. The prosecutor asserts in that motion for reconsideration, and as he told me, it seems that those reports came in October. They were kind of put in the file, and when he pulled out the file to prepare the case for trial is when he saw them around Thanksgiving, and then by December 2nd, he was getting the buccal swab. On top of that, it ordinarily takes 90 days for that final lab report to come in. So even had he acted right in October, 90 days would have put it past the point of trial to get that final lab report. But again, he did the best he could. He requested that the lab in December expedite those final reports. And they actually were expedited because they came in January 11th and January 12th, which is even before the trial date, which I believe was set for January 17th. So all of this is to say that this wasn't like an intentional delay on the part of the trial prosecutor. And in fact, as you can see from the facts, the co-defendant was a drug addict just as the defendant. And so the trial prosecutor actually had serious contemplation over whether or not to even dismiss and reissue the charges when the trial court denied his request for an adjournment, or to just move forward without the DNA evidence. It did not give the prosecution any sort of tactical advantage to dismiss and reissue the charges in this case, because there was a real risk of losing the co-defendant. And what actually occurred behind the scenes is that the co-defendant, she had to be located for that second preliminary examination. She went missing, and the police had to intervene and locate her. So it wasn't like, okay, the prosecution's going to dismiss and reissue this case to get an advantage. It actually jeopardized the prosecution's case. So I would just push back on the fact that this was not a sham dismissal. The second thing I want to bring out is, if it's true that there's no case law that says a, second parole detainer has to be issued, but then there's also just like no case law that says the opposite, then I would point to this court's role as an error correcting court. This court is principally charged with the duty of rectifying lower court errors. And so if it's not clear in the law whether or not a parole detainer had to be issued, as opposing counsel is saying, then you certainly can't fault the trial court there's no error on the part of the trial court if the law is actually unclear. But I would also just default back to the people's position that there is no law saying that a new parole detainer had to be issued. And so there's no basis for opposing counsel's position that, a new parole detainer had to be issued. That's just not the case. And primarily, Barker is the present and definitive test as relates to speedy trial claims under the Michigan Constitution. Grommet made that clear, and if Grommet didn't make that clear, then Collins made that clear, where the defendant actually was raising a speedy trial claim under Michigan's Constitution, and the Michigan Supreme Court applied the Barker factors to that speedy trial claim. And again, this is an error-correcting court. We have Collins, where we have a claim under the Michigan Constitution, and the Michigan Supreme Court applied Barker to that claim. The trial court was following Collins. It committed no error in applying Barker to Bertrand's speedy trial claim. And again, this court also brought up Williams, the 2006 case from the Michigan Supreme Court at page 250, where the Michigan Supreme Court again says this court adopted the Barker standard for speedy trial claims. And so I would just focus on the fact that this is an error correcting court. The trial court followed the predominant law, and no error was committed. As to why Barker is the predominant test, and it should be the test as opposed to Hicks. Hicks did not deal with the Michigan Constitution in its current form. Hicks dealt with the speedy trial right under the Michigan Constitution of 1908, Article 2, Section 19. It did not deal with Article 1, Section 20 of the current version of Michigan's Constitution. On top of that, when you look at Westlaw, and you look at speedy trial claims, Barker is repeatedly applied over and over and over again. We have 256 cases in Michigan alone, 105 of those published, that discuss the Barker factors while addressing speedy trial claims. By contrast, Hicks can be found in only 13 cases in Michigan. 12 of those are published, and not even all of them are applying Hicks. They might just be citing Hicks, but they're not necessarily applying Hicks. And Barker really encompasses Hicks. When you look at Hicks, the defendant in that case did an interlocutory appeal because it had been 18 months from the time of his arrest to the time of the interlocutory appeal, and he still had not been brought to trial. And the Hicks court ordered that he be brought to trial within 30 days of that order. And so the delay in Hicks was about 18 months. Well, the whole thing with Barker is the length of the delay. That's one of the factors. If it's 18 months or more, it's presumptively prejudicial. So Barker effectively encompasses Hicks. And when you look at this case, the delay was only 15 and a half months. And a lot of that was caused by Bertrand himself. If he had agreed to the adjournment that the prosecutor requested, certainly his trial wouldn't have been as late as August. And on top of that, when the case was dismissed and reissued, they had a pretrial in March. And he could have, if he was very serious about his right to a speedy trial, he could have said, I want a trial date. Instead, both of the parties agreed that the case be adjourned for another pretrial. And another pretrial occurred in May. And then it was only in May that the case got set for August. And so Bertrand was a contributor himself to not being brought to trial faster than August of 2023. On top of that, so the Hicks test is just very vague. The delay has to be reasonable in all the attendant circumstances. Okay, well, Barker accounts for the relevant circumstances when it accounts for the length of the delay, the reason for the delay, the defendant's assertion of the right, and prejudice to the defendant. It effectively encompasses Hicks, and it's also actually gives courts clear factors to hang on to when assessing speedy trial claims, as opposed to Hicks, which is just reasonable under the attendant circumstances. If anything, Barker protects the right to a speedy trial greater than Hicks ever could. So I'm not sure why opposing counsel is arguing that Hicks ought to apply to speedy trial claim in Michigan. Let me just see if I have additional points. Yeah, I mean, I think that covers, oh, no, it doesn't. As to the parole detainer issue, one of the things that opposing counsel repeatedly asserts in his brief is that Bertrand was serving dead time. He was not serving dead time. He was on parole for delivery or manufacture of methamphetamine. He was sentenced to 4 to 20 years. He served about, and that sentencing occurred in 2018. He was released on parole in 2021. So he had only served like a part of his sentence when he was paroled. When he was detained on this offense, all of the credit from sitting in jail those 506 days went toward his sentence for delivery and manufacture of methamphetamine. And so it would be double dipping to also give him jail credit in this case for credit that he's getting on his previous sentence. And so when I was reading opposing counsel's brief, it's almost like there's this sense of unfairness because he's sitting in jail serving dead time. The time is not dead because he's getting credit for that time on his delivery manufacture sentence. And so I think that covers all of the key points I wanted to make, but I'm happy to answer any questions.
Any questions?
She answered the question that he wanted us to ask her. So
Thank you.
Thank you.
Rebuttal, you have about 8 minutes.
Couple points. First, as to this court's role in deciding the detainer question, the prosecution, I think, has framed this it's right that this court is primarily an error correcting court. That's true. But counsel seems to think that this court can only apply cases that are on all fours with the facts before them. And that's simply not true. That's not this court's role. That's not any court's role. If the prosecution were right, when for anyone to come to a court and get relief, they would need the exact facts as some case before them, or they'd have to go to the Michigan Supreme Court. That's not right. Courts look to old cases and apply those rules to new cases. They do it all the time. So this court does not need, if this court wants to apply Allen, it doesn't have to look to a case with the exact number of days of credit of Allen. That's just not how courts do things. And furthermore, this court can look to other factual differences and extend Allen to those also. So it is definitely this court's role and duty to solve this question, not just punt and say we're an error correcting court. So I think this court does need to answer that question. As to the speedy trial arguments, the prosecution said today, it said in their brief, this is not a sham dismissal. The counsel said the prosecutor did the best that he could. There was nothing intentional about the prosecutor's actions. I don't know. I don't think anyone can know what the prosecutor's intentions were, or if they were working hard, or if they weren't working hard, or if they should have got the DNA test earlier. It doesn't really matter. When they did the dismissal, everyone knows. The judge knew, the prosecutor knew, defense counsel knew they weren't really dismissing the case. They were immediately refiling. Everybody knew that. It wasn't a dismissal. The reason they did a air quotes dismissal, a sham dismissal, was to reset the speedy trial right. The judge was ready to go, Mr. Bertrand was ready to go to trial. Defense counsel was ready to go to trial. The judge was ready to go to trial. The judge told the prosecutor, no more adjournments. You cannot have another one. All the things that the prosecutor told you today about how the prosecutor was working hard, the reasons they didn't get the swab, all of these things, the prosecutor told the trial court all of that, and the trial court was not interested. The trial court said those were not acceptable reasons for an adjournment, and the speedy trial right required the prosecutor to go to trial. The prosecutor said no and exercised its raw exercise of power, not of authority. Don't believe prosecutors have the authority to circumvent the speedy trial right, but in a raw exercise of power, denied Mr. Bertrand's right to a speedy trial himself. And that is should not be permissible under the federal or Michigan Constitution. And if your honors I don't need to look to the Michigan Constitution to say that this sham dismissal is impermissible. We can win under the Barker factors too. The dead time prejudice to Mr. Bertrand, 506 days, not credited to this offense. I understand prosecutors often say there is no dead time. That's not how IDSIAC works. I understand the point of that. But the point is that Mr. Bertrand spent 506 days awaiting trial, and that was not credited to his sentence. And when we talk about, and there's a lot of recent, there's at least one recent statement from our Supreme Court, Justice Bolden, talking about even people that are getting jail credit, about the personal prejudice of being, of awaiting trial and the stress. That's a real thing, and our Supreme Court is taking notice. Being in jail is being credited toward your sentence is one thing. Mr. Bertrand waited 506 days, and that didn't get credited towards this case.
What's the prejudice to his defense?
Prejudice can mean multiple things, Your Honor. I will answer that question, but if I might.
We know there's prejudice to the person and prejudice to the legal defense. What was the prejudice here to his legal defense during those 506 days?
That's a very interesting question. And if I might, there doesn't, and I will address it briefly, but if I might just add in the caveat that that's not required. The personal prejudice in this case is extreme, and that he suffered 506 days of incarceration that was not credited to his sentence. As to his case, and thank you for your indulgence. That's a very interesting question because the prosecutor is arguing, at the time they argued, we absolutely need this DNA evidence. We absolutely need it. And then, we have to have it. And so they delayed the case to get it. So you could think that Mr. Bertrand's case is prejudiced because they got this stuff that they really needed. That's what they said at the time. That's why they did the sham dismissal. That's why Mr. Bertrand waited the 280 more days. They thought it was important then, and now they're coming to court and saying, no, it was never important. And now we're learning for the first time, this is extra record evidence, that the co-defendant who testified against Mr. Bertrand was in the wind, and that complicated things for them. Maybe she had not been there if they had went to trial. We don't know that. They didn't say that on the record at the time, but they're telling us that now. So maybe they wouldn't have had their star witness if they'd gone to trial at the time. We don't know that. There could have been so I think that there is ample prejudice to Mr. Bertrand's case as well. And so, and again, I just,
What you're essentially saying is the time the trial should have started here, the prosecution wasn't ready for trial. So the prejudice to his defense is that by delaying, you gave them an opportunity to, I guess, flesh out more evidence that they didn't get in a timely fashion.
absolutely. And if I can just elaborate on that point a bit more, the prosecution themselves at the time claimed they weren't ready for trial. If we take, I mean, right? And just for the reasons they said on the record about the DNA evidence, they're telling us now in open court, they also had a problem with their star witness. I didn't know about that till just now, but that would have been a big problem for them, right? So, so yes, there was, they told us then and are telling us now they had problems with their case and they benefit greatly from the dismissal. And we don't need a separate Michigan rule for that. And so, and again, if I might, just the notion that there's nothing intentional about the prosecution's actions. If we can break this into two timeframes, I think what the prosecutor is saying is there was nothing intentional. What sister counsel here today is saying is there's nothing intentional about the trial prosecutor's actions leading up to the sham dismissal and their delay. And again, we don't have to solve that question, but we do know that their delay in doing the sham dismissal was intentional. That's obvious from the record and no one could dispute that. That was the whole point. Trial counsel said it, trial prosecutor said it on the record. There's no debating that. So this absolutely was an intentional circumvention of Mr. Bertrand's right to a speedy trial.
Okay.
Thank you very much.
Thank you.
Thank you both for appearing. This matter will be submitted for decision.
Thank you.
The next case is docket 15, case number 371582, People of the State of Michigan versus Sean Rosenbrook. Morning.
Good morning, I police the court. Yeah, a lot of static. My name is Robert Rahman. I'm representing Sean Rosenbrook, the appellant. I know the court has read the briefs and the record thoroughly. I just wanted, first of all, to address some of the points that were made in the appellee brief. The first one is regarding my first argument that the self-defense instruction should have been given in this case. And I think that was a clear error. My client had met what we call the burden of production, at least providing evidence to justify giving that jury instruction. And I think the appellee brief placed a lot of emphasis on what I would call a closing argument to make the argument they had proven their burden of proof beyond a reasonable doubt there wasn't self-defense. That's different. That's not what the trial court should be analyzing when deciding whether this jury instruction should be given.
Wasn't the point, though, that the determination was made that he was the one who brought the gun into the house?
Can you repeat that, Your Honor?
I know it's with respect to this regarding the felon in possession, but there was no self-defense instruction that was given. So it comes down essentially to a credibility determination. Is that what you're saying? That they should have given it because it was up for the trier of fact? I didn't understand.
Go
ahead. I'm sorry.
Yes, I agree. I believe that is a credibility. That's the jury's providence. That the only thing the trial court should be analyzing whether to give that jury instruction if there's evidence to support it. And there was. He testified repeatedly that Mr. Rosenbrook, that she pointed a gun at him, he grabbed it, and that's why he did, because he was in fear of his life. He was defending himself. And a lot of what's being said in this appellee brief is something the prosecutor should be arguing instead in closing, and why it isn't self-defense. Now, that's, I think, another important point is the prosecutor always has the burden of proof. It doesn't shift to my client about self-defense. He just needs to produce the evidence, the burden of production. But the burden of proof always with the prosecutor. So they can argue, well, and I know there was even a statement that the wife claims he made that I bought the gun for self-defense. So that might have been indicated possession at some other time. But again, that is something that they can argue in closing, that maybe he was in possession and not defending himself. I would also like to point out, I don't agree with the argument that the review should be plain error. The defense counsel clearly objected to not having the self-defense instruction on the basis that Mr. Rosenberg had a right to defend himself. I don't agree that just because you cited some other case law or the U.S. Supreme Court, that is different ground. I think we still review this for abuse of discretion and de novo. And I would also point out, if you read the transcript, the trial court clearly said Mr. Rosenberg did not have a right to defend himself. That's the same ground. Prosecutor was also going, I don't know why they thought there was nothing in the Michigan case law. This was, Dupree is fairly old, I think it's 2011. But that's clearly wrong. If you misapply the law and misstate the law, that's an abuse of discretion. There was also argument about constructive possession, which I agree that applies to felon in possession. You don't actually have it in your hand, but if you knew where it was and you had access to it, that could be also possession. And there's a lot of argument about self-possession, or that he wasn't actually in self-defense. For example, he was returned to the house by the police, and the argument is, well, he knew what a gun was. And so therefore he was in possession at another time. And I would say, well, one is he's been brought there by the police, so I don't know if you can argue he intended to be around it. The other, whether he could have access to it with the police there. There was another reference to the safe, the fire of the gun safe. And he does say at some point, he believed the rifle came from that. And that's where also he would say the brass knuckles and the double-bladed knife came from. So again, the argument is saying, well, if he admits that he got that's where those items came from, he must have had possession of it at some point. That's not what he's saying. He testified that I don't have access to that safe. I have a key. So that's the production. That's the evidence that he's given to the court for self-defense. He didn't have access. He doesn't know how the wife got the rifle. He doesn't know how the knife and the double-bladed.
Well, he might not have testified to it, but you can hear him very clearly on the video say, I brought a gun here. I brought a gun here. And he basically says, so what? Are we just supposed to disregard that?
Well, I watched that video. I didn't hear that, but you said it was one of the videos where he made that statement.
Yeah.
Okay. Well, again, if that could be contradictory statements that go fall in line. I know the wife said he bought that rifle for self-defense. But in his testimony, he had made that production sufficient evidence. So again, could a reasonable juror not find it beyond a reasonable doubt that it was self-defense? Yeah. Even with that statement in the video. So they might look at that and I don't know how the jury might look at that. They might say he was just saying things because in the heat of the moment. I mean, there's a lot of ways they could look at that. But the analysis again should be, did he produce evidence that this was self-defense, that we could have a self-defense instruction? In his own testimony, he did. I do believe this outcome determinative. So I was just, I just noticed I didn't put this in my statement of facts, but the information felony, if you look at the separate count, and again, the trial court referred to carrying a concealed weapon when making the ruling, not to give self-defense instruction. And I wonder if she didn't understand that carrying a concealed weapon was referencing the double-bladed knife, not the firearm. So that does make a difference. The possession of a dangerous weapon was on the brass knuckles. Now, he was convicted of those, but there is no other firearm charge against him regarding the firearm, except for the felony assault and the felony in possession. And those are at the height of this issue. He should have had the self-defense instruction on felony in possession. He was acquitted on felony assault. So there was an argument there. Well, maybe they didn't believe the defendant. True. That's not a burden of proof. The burden of proof is always on the people. If they didn't find him guilty of felony assault, certainly possible. Maybe they still don't believe him, but they may not still believe that burden has been met by the people. So it's definitely outcome determinative. Because of that lack of self-defense instruction, they were found guilty of felony in possession. That's the only, and also felony firearm, which is premise on the felony in possession. And I would argue, I don't agree that it's plain error, but again, this is a substantive right that was affected and should be corrected by this court. Again, my other 2 points are mistrial. There was a motion for mistrial regarding meth use. My only, the people are saying that once you make an objection, it only applies in that period of time. I think that once the court has made it clear that you can't refer to this drug use, it shouldn't. I don't understand why that can't continue for the duration of the trial. Why it has to be objected over and over again. And then finally, third point would be sufficient notice of using felony firearm. Most of the time, you see prosecutors actually charge multiple counts of felony firearm, referring to whatever the predicate felony is. That didn't happen here. I think that can make a big difference as far as the defense attorney preparation for the trial, and also the jury instruction. That's all I have that's it for my summary. If anybody has any questions, I'd be happy to answer.
Okay, thank you. You have
Yeah.
time for rebuttal.
Thank you.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. As it relates to issue 1 and why we believe it's unpreserved, the trial counsel objected on Bruin grounds, which is the Second Amendment United States Supreme Court case. And Bruin clearly does not apply to convicted felons. And I believe in Rahimi, which is the case that followed Bruin, based on Justice Kavanaugh's concurrence in Bruin, that the Second Amendment right to bear arms does not apply to felons. So his sole reason for requesting the self-defense at trial was based on Bruin, which is not applicable to him. So on appeal, he changes his argument to essentially the Dupree argument, which is when a convicted felon can use self-defense as a defense to a felon in possession felony firearm charge. And we outline that in our brief, but we believe that's plain error based on it not being properly preserved. However, when you're looking at the Dupree test, kind of assuming he can meet the first 4 requirements of it, he cannot meet the 5th requirement to be eligible for that jury instruction, which is that he terminated his possession of the firearm at the earliest possible moment. So I believe the trial court's ruling was essentially that a convicted felon can never take advantage of that defense. And I don't think that's correct. Dupree says here is when they are able to take advantage of that, if the evidence at trial presents. And if you look at his behavior after the fact, assuming his version of correct events is accurate, that he did not terminate his possession of the weapon at the first available opportunity. He actually took affirmative steps to hide the weapon. He lied about where the weapon was, whether the weapon was even there. At one point, he said, if you let me talk to my wife, I'll tell you where it's at. They let him talk to her. He still didn't tell him where it was. So just even in the most favorable light to him, the trial testimony, the evidence, even from himself, he did not terminate his possession at the earliest possible moment. So whether it's plain error, whether it's preserved or not, he was not eligible for that jury instruction.
What's your interpretation of the video? So your opposing counsel says he didn't hear on the video defendant say 2 times, that he brought the gun there.
And I
I'm
think
sure you reviewed the video. What was your take on that?
that's what I recall hearing. Now, it has been some time since I've watched it, but I do recall that being what was said on the video. And I think if you look at what the jury found, I think you can infer that that's what the jury heard as well.
Well, if we agree that he said that, then how does he even get past the second part of Dupree, which is the defendant did not negligently place himself in a situation where he could be forced to engage in criminal conduct? I mean, if he's a felon that brought a gun to the house.
Well, and that goes along with the wife's testimony, which is why I said even in the light most favorable to him. I mean, her testimony was he bought the gun. Now, I think you can infer she thought it was to kill her. He kind of hinted, no, it was protect him from his girlfriend. But even if you take that in the light most favorable to him, to Your Honor's question, he still doesn't get that instruction, but even, again, even assuming he can meet those, even, I think you can resolve this just based on that, the fifth element of the Dupree test. But I believe, to your point, Your Honor, as well, Judge Wallace, that he wouldn't get it based on that either. If he brought that gun, then he's clearly possessing it not for self-defense purposes, because the case I cited in my brief discusses how this is a very narrow exception to felon in possession laws, and it can't be, assuming he's said, I brought this to protect us both from my girlfriend, that's not enough. Some general overarching need for protection is not enough. It's got to be an imminent, immediate threat. So I believe, based on your question, Judge Wallace, he would lose the argument on that ground as well, whether it's preserved or unpreserved. Unless Your Honor had any questions.
Anything?
No, I would just rely on the brief.
Thank you.
Thank you.
Rebuttal? Okay, thank you both for
Thank you.
appearing today. This matter will be submitted for decision. Next matter is docket 16, case number 372465, People of the State of Michigan versus Richard Frank Jackson.
Your Honors, Charles Cavello, appearing for the appellant Richard Jackson.
Morning.
I have nothing to add to my brief. If the court has any questions, I'll be glad to take them.
I don't believe I do.
We don't have any questions, but we appreciate you appearing this morning.
Thank you, Your Honor.
Thank you.
Thank
This
you.
matter submitted for decision.
Have a good day.
Docket 17 is case number 370531, People of the State of Michigan versus Emmanuel Williams. There was one party endorsed, Mr. Strauss.
Yes.
All right. It was 11 o'clock. This matter is scheduled for 10 o'clock, so the matter is submitted on the briefs. Thank you. Next case is docket number 18, case number 371880, Lorinda Reed versus Sheila Aluat. I believe we have one party. Yes, remotely, Ms. Cruz. Okay,
Morning, Your Honors. John Holmeyer for Appellant State Farm. I know there's a lot of issues. I'm going to try to reserve most of my time for rebuttal. Because there's a lot of issues, is there any specific questions or any areas of clarification the panel would like to start with? If not, I think you can use plaintiff's calculations of the medical in the lower court as kind of an analogy for how the evidence went when you get to trial, because there's no real rhyme or reason to how the evidence gets put in or how the evidence progresses throughout the case. If you look at the very beginning, when initial disclosures are given, requests to produce discovery responses, the total medical is $500. Fast forward over a year later, after discovery has closed, they send a demand, plaintiff sends a demand to State Farm where the medical is $8,536. And that's not medical bills that are owed by State Farm. That's how much is left over what the plaintiff owes the health insurer after the health insurer had paid all the bills. So it wasn't even medical bills that were submitted in the demand. It was the amount of money that the plaintiff owed the health insurer left over from what they did not pay. Then State Farm files its motion for summary disposition after discovery closes. In plaintiff's response to summary disposition, they allege $10,463 from about a dozen different medical providers. Fast forward to trial less than 4 months later. Plaintiff's proposed exhibit 31, it's appendix 15 to State Farm's brief, lists $72,954 in medical, which is up over $62,000 from 4 months prior. And all the bills that are included are for dates of services that are before she sent her demand for $10,000 in the first place. Then we get to day 3 of trial where they're fighting over exhibits, what comes in, what comes out. They're fighting over what's in the claim file, what's not in the claims file. And counsel states on the record, this is page 22 of the February 15th transcript, the total medical is $79,100 $188.44, which is different from the proposed exhibit. And then just 20 pages later, the final exhibit that they submit to the jury lists medical in the amount of $145,066. So in a matter of minutes, the medical goes from $79,000, $188 to almost double, $145,066. And there, all the while, there's no foundation for any of this medical, which brings you to State Farm's motion for directed verdict. So even if you skip past the discovery violations, you skip past the motion for summary, you skip past the motion to exclude evidence or preclude her from producing stuff that was in discovery, you're left at directed verdict with no testimony that she was entitled to wage loss, no testimony that she's entitled to household service or attendant care. The only thing that's in the record at trial is one disability certificate for 1 month of wage loss, 1 month of household service. No testimony whatsoever about any of the bills that were submitted into evidence, let alone testimony about the reasonableness and customary of the charges, which is required under cases like Attard, required under cases like Fountain, which I know is unpublished, but it was released last year. And it takes you through exactly what a plaintiff needs to prove in order to get to a jury on incurred expenses. So I don't really need to belabor the point, Your Honors. I will take a page out of Ms. Davis's argument in the first case. This is an error correcting court, and I think there's plenty to work with in the trial court.
I'm wondering, were you the attorney handling this at the trial?
I was not the trial attorney, Judge. Neither of us were, unfortunately.
Okay.
And if the question is what was in the record and what was not, my associate, Mr. Campbell, we went after trial to Wayne County and tried to get absolutely everything that was filed with the court. And there was half the file was there.
There's a lot of talk about the claims file, who had the claims file, who didn't have the
agree.
claims
And,
file.
You know, I have tried, I haven't tried 100 cases for State Farm, but I've tried about a dozen of them. And every single time a claim file is entered into evidence, it is bait stamped. And there is not one exhibit on appeal that I see bait stamped by the plaintiff. So if it did come from the claims file that everybody's talking about, it should have a bait stamp in the bottom corner of it. And I haven't seen that. So if there's I understand that the argument on plaintiff is, well, State Farm can't prove it wasn't in the claim file. It's not our burden of production and it's not our burden of proof. And the only way to prove whether it was in the claim file or not is to show the bait stamp on it. And I have not seen any exhibits on appeal in this record with a bait stamp.
Can we talk about your client's explanation of review forms?
Sure.
I mean, how can you possibly argue that the opposing party is required to give your client another copy of a document that they prepared? In other words, State Farm creates an EOR, sends it to the plaintiff, says, here's our explanation for how we reviewed this bill.
Mm-hmm.
How can you claim that somehow you don't have possession of that when your own client created it?
So, there is the EOR basically says we're going to pay this bill or not. And the EOR explanations in this case are that health insurance is primary. And the EORs that are presented by the plaintiff are not for every single bill that was presented at trial. It's for a limited number of bills. And the explanation of review is health insurance is primary. Health insurance is primary. It's not that.
Hold on. Can we just agree? Because I think then we agree.
Sure.
We can agree then that no plaintiff ever has to give your client back a copy of the EOR that your client gave to them in order for it to be admitted at trial, right?
No.
Because that's essentially what you've argued in the brief and they argued below as well. And that's just not a thing, as the kids would say.
Well, and I agree with you, but I think there might be, there's a discrepancy between an EOR and an EOB from the health insurer.
Yeah, sure.
And from State Farm.
Absolutely. That had nothing to do with my question.
Okay.
I was
yes.
just talking about documents created by your client because I thought it was strange that you were essentially arguing in your brief that somehow the plaintiff had to give you those back in order for them to be admissible.
No, and there's
obviously not true.
And I would agree 100%. There's about a handful of EORs submitted from State Farm. The rest of them are from the health insurer.
I think what really happened here is when you were writing this, you just weren't real careful. You were grouping EOBs in with EORs.
That may be very well.
And
true.
what you were really talking about were the EOBs.
Correct.
Yeah.
Yes,
Okay.
I would agree with that, Your Honor.
Okay, anything else at this point?
And just a quick clarification, Your Honor, that those EORs, EOBs would have to do with the health insurance, which, is also above and beyond any evidentiary or discovery issues. Thank you.
Maybe you have
Thank
time
you.
for rebuttal. Let's hear from Ms. Cruz.
Good morning, Your Honors. Kelly Cruz on behalf of Leandra Reed, the appellant. If I could first address the claims file issue. It was offered as an exhibit by the plaintiff. However, defense counsel indicated that he too had planned to admit the claims file, and so there was no argument. It was admitted. There's no indication that it wasn't. I understand where brother counsel is coming from because I too have not been able to find the claims file itself. But that is a document that is within the control of State Farm. So I'm a little surprised that they were unable to provide it to the court in the appendix and by extension to us. But there is no doubt that the claims file was admitted. There's no doubt that the jury had access to that. And there's no doubt that the judge had access to that when he made his various rulings. So whether or not something was or was not in the claims file, none of us can say that. But what we do know is the judge was able to determine that because he had the claims file. It was there. It was admitted into evidence.
But Ms. Cruz, I guess as a former trial judge, maybe I was an odd duck, but I always made sure to keep all the exhibits and I kept the exhibit list. And I assumed that both trial counsel would have had that exhibit as well. So did everybody check with trial counsel? Did everybody check with the court to see if they had it as well? Because I just don't understand how we couldn't be able to find this claims file because the file might have things in it and might not have things in it. As brother counsel said, those pages should have been bait stamped so you knew what you were talking about. I mean, I don't get it. And so can you tell me what efforts you made to try to locate it?
No, I didn't try the case either. I'm just appellate counsel, but I did communicate multiple times with trial counsel and with their office in an effort to track that down. And I could never get what was admitted to trial. And I think there was some reference to like a flash drive, that would be an option to use a flash drive. And it looks like the court decided not to go that route because all indications were that this was a very voluminous claims file. It sounded like perhaps thousands of pages. So I don't know if that's not why it was retained by the court, but I tried to track it down as well because I thought that was an important feature, or important issue, but I think that because we don't have it, we have to look at what the trial court had, and the trial court did have it. And repeatedly indicated that several of its rulings were based on the fact that certain documents were in the claims file. And if I could go back to what Judge Feeney brought up, that a lot of the documents, and I can give you a whole list of them, but so many of the EORs were in the claims file. We know that because we have the State Farm documents that show that so many of the medical bills that are at issue were submitted to State Farm because State Farm responded. Also, and I think it's at pages 2088 to 2089, we know, for instance, that capital surgery, which had the biggest bill, that was submitted, or a good part of it was submitted to State Farm back in 2021, because right on that health insurance claims form, it says it's directed to State Farm. So, the fact that there's issues, this issue is kind of undermined by how many documents we do have that show that State Farm was in receipt of this information. And I will say that, State Farm never, at least there's nothing in the record, that State Farm ever issued any type of denial or a letter to the plaintiff or her attorney terminating benefits. So all of this information was known to State Farm. The EORs show that, and as well as the health insurance claim form. So I think that they certainly had notice of all these bills. Now, one of the things I would like to address with respect to the directed verdict argument that counsel raised. And I think that comes in connection with their contention that plaintiff didn't provide sufficient evidence of the reasonableness and customary nature of the of the medical bills. And first, I would just point out that the jury instruction does not instruct the jury to make the determination of whether or not the billing was customary. And it's the jury instruction that was given in this case. The jury instruction only tells the jury that they have to determine were there allowable expenses which consist of reasonable charges for reasonably necessary products, services, accommodations for the plaintiff's care, recovery, or rehabilitation. There's nothing in the jury instructions that requires the jury to consider if a bill was a customary charge. And so there's that kind of eliminates the defendant's argument that the jury would have to speculate on that issue because there's nothing for them to speculate on. They were never asked to consider that. But I'd also point out that in the directed verdict motion made by defense counsel, he told the judge, this is what the plaintiff has to prove. The plaintiff has to prove, one, and I'm quoting, the charge must be reasonable. Two, the expense must be reasonably necessary. And three, the expense must be incurred. And that's at page 363 of the appendix. So those are the only three issues that the defendant asked the court to make a determination on in connection with their directed verdict with respect to the medical bills. And so to now bring up later in a motion for judgment notwithstanding the verdict or here on the appeal, the issue of customariness, I think has been waived. But even if it hadn't, at least with respect to the capital surgery and the physiatry and rehabilitation associates bills, there was proof in the record by the testimony of Dr. DeGabar when he said, we bill everyone the same. And that's his quote, we bill everyone the same. So when you take that testimony in the light most favorable to the plaintiff, the non-moving party, you have to, I believe, come to the conclusion that the customary, if there was a requirement that the plaintiff prove customariness, that it was satisfied by that. Dr. Gabar has an ownership interest in both of those entities. And so with respect to those bills, I think even if they had to prove that, it was satisfied. Now,
Counsel, could you address brother counsel's argument regarding the dramatic increase in the amount of damages and the amount that they were seeking?
yeah, so you know, I can't tell you why things change between the initial disclosures and say the response to the motion for summary disposition. I can say that I thought the response to the motion for summary disposition responded to the arguments made by the defendant. And that argument was, you didn't give us any, and I think any is important, indication of what damages you're claiming. And then in the response, certain things were listed. I don't know why the capital surgery and physiatry and rehabilitation associates bills were not included in that list. They had certainly been incurred before then. They had been provided to State Farm before then. I don't know why they weren't in that list. With respect to what happened at trial, I think trial counsel for the plaintiff explained that she simply made a math error. That when she added things up, she added them wrong. And when she double checked her math, and this is in the transcript, that she realized she had given the court the wrong number.
But I mean, that's a difference in, like, you don't go from 5 digits or 4 digits to 6 digits on a math error. I mean, I went to law school because I can't do math and go to medical school. So
you and me both.
yeah. So that doesn't seem to ring very true with respect to that.
I think what I'm guessing happened is when she added the first time, she forgot to include one of the bigger bills. And that's when she went back and re-added, it wasn't so much that I didn't add 1 and 1 correctly. It's just that when I'm adding all these, I forgot to include some of the bills. And that's how I read the transcript as to why things changed. And it seemed like the court was satisfied, the trial court was satisfied with that explanation. So unless your honors have, let me just address one other thing. You know, the defendant started the reply brief by indicating that this was a trial by ambush. And there's one thing I do want to point out about what information the defendant did have prior to the trial. And I think it's really important that it's considered that the plaintiff signed dozens of authorizations and gave the defendant access literally to every part of her life, her education, all of her medical, all of her employment. I mean, everything in her life, her social security records, everything she signed authorizations for. So they had those in the transcript. It indicates that the defendants.
If I can interrupt you, Ms. Cruz, respectfully, I don't think it's the defendant's job to have to go out, search through all that information, figure out what's owed and what's not owed. I don't think that's a good reason.
Well, and Your Honor, I'm not suggesting that, but the suggestion was, hey, we didn't even have this information. So they certainly did,
They
because
still,
the trial transcript says we ordered all those records.
even if they get all those records, and I don't know what they got and what they didn't get, but it's not their burden to have to go through and figure out and sort through all those records and figure out what the plaintiff's been paid and what she hasn't been paid. It's the plaintiff's burden to come forward and show what's owed. So I don't really.
Okay,
agree
well,
with that
and Your
argument.
Honor, I think that the plaintiff satisfied that burden at trial when they introduced the medical records and then they presented to the jury what was still owed by State Farm. And one thing to keep in mind with respect to the increase in the records or the medical is that for a long time, Ms. Reed either had health insurance that her employer was paying or that State Farm paid, but that ended. And I believe it was at the end of May of 23. So after that point, State Farm would have been primary, which also accounts for an increase in how much was owed. You know, when there was health insurance, it was mostly copays and deductibles. But after State Farm, or I'm sorry, after there was no longer any health insurance, State Farm became primary. So unless you have any other questions, I will rely on the remainder of my brief.
Okay, thank you. Any rebuttal?
And we can speculate about what was in the claims file all morning. At no point did the judge look in the claim file to make sure that something was in the claim file before he introduced it into evidence. And you can look at the transcript of February 15th. The objection is, I've never seen this exhibit before. Plaintiff's counsel says it's in the claim file. The judge says, oh, it's in the claim file. I'll admit it. And that happens multiple times. Even co-defense at one point says, Judge, this is the first time we're seeing these exhibits. The justification for entering them every time is it's in the claim file. But there's no actual review of the claim file.
But the claim file was your client's exhibit Z, correct?
It was a, yes.
Who's, under the Michigan court rules, whose obligation was it to file that with the court so that we could see it?
So it would be defense counsel's, but it was also an exhibit for plaintiff counsel. So it would also be their obligation as well. I agree.
But I mean, it's State Farm Exhibit Z, which means under 7.210C.
Right.
The party that proffered that exhibit is required to file it within 21 days.
I would agree.
And there's no dispute that defense counsel did not do that.
I would agree.
So one other thing I think we can agree on is if there's an EOR in the record about a certain bill, doesn't matter what bill, that EOR is proof that State Farm had possession of that bill. Otherwise, they couldn't have examined it. Is that fair to say?
I agree. If there's an EOR from State Farm regarding a bill, there's no dispute that they received that bill.
Yeah. Okay. Thank you.
I would agree. But as the profferer of the evidence, it is plaintiff's obligation to file it with the court. State Farm is not using the exhibits we're talking about for a defense. Plaintiff is using them in their case in chief. That's the only distinction I would draw, Your Honor. And the other thing about.
But you are, though. You're saying, hey, these documents weren't given to us. And the response is, yes, they were. They are in the claims file.
Correct.
And so your evidence that they weren't given to you would be the claims file, which you did in fact have admitted as evidence. You just didn't file it.
And I agree that both, yes, and I understand the question, Your Honor, and I agree both sides. If we all had the claim file, which claim file was submitted, we wouldn't even be talking about this because we would know exactly what's in the claim file and what's not. The only other thing I will add is with regards to the customary plaintiff having to prove it's customary, that's axiomatic. Obviously, it's not in the jury instruction because that's a threshold inquiry made by the court. The only thing that makes it customary is that, as counsel said, you charge everyone the same, whether insurance is involved or not. The problem is Dr. Gabber didn't testify to anything about the billing. Dr. Gabber testified, I have people for billing, don't ask me any questions. She's referring to Dr. El Tahawi's testimony, and his testimony is, we charge all insurance the same. We charge health insurance the same, auto insurance the same, Medicare the same. He never once says they charge lay people or people without insurance the same, which is the inquiry for a customary charge. And that's why it's not in the jury instruction. And the final thing I'll say is, Your Honor, I read a dissent of yours a couple of weeks ago in the Nationwide versus State Farm case, and I agree 100% with it.
Ask counsel, did you ask defense trial counsel if they bait stamped that claims file before they brought it to be admitted as an exhibit?
Your Honor, I did not make that inquiry to trial counsel. I just, and obviously this is outside the record, that is standard procedure. You can't produce a claim file that not bait stamped.
And if defense counsel was so frustrated by the court doing what you claim that they did, and I have no reason to think that they didn't, why wouldn't they say, okay, if it's in the claims file, what page is it on? Show it to me before the court admits it.
I agree, Your Honor. The only thing I can think of, it's a lot harder to try cases on your feet than it is to be in the Court of Appeals. And, and you can see what happened in this case, right? Like the motion for summary is basically a litmus test for what's that issue? Because she's chasing the third party claim the whole time. Health insurance is paying every single step of the way. Until we get to the point where State Farm files their motion for summary, then all of a sudden the PIP becomes an issue. And the no-fault claim goes from 8,000 to 10,000 to 120,000 to the ultimate claim of 190,000. And obviously this is all speculation based on the record.
Well,
Yeah, go ahead.
Well, I was just going to make a comment. I was going to say, I'm glad that some of the carriers have returned to a very wise practice that used to be pretty common when I started, but went away for a while there, which was, pay the health insurance premium so that you end up saving money.
Yeah.
When I started, that was pretty standard. And then all of a sudden it didn't happen for a long time. And looks like now they've gotten back to that, which I think is wise.
In some cases, I think you're right on. Absolutely.
So, the point you made about being on your feet and sometimes overlooking stuff, I think that's the problem with the customary argument too, which is that trial counsel didn't actually raise that.
Well, he did in his motion for directed verdict. And that was actually filed with the trial court. And then they argued it.
He didn't raise it wasn't that in the,
But there's
wasn't that a
no,
post-trial motion?
so he raised it in the directed verdict motion, which was actually filed with the trial court. They argued it after plaintiff closed her proofs as well. Yeah, and it's plaintiff's burden. There's case law dating back 20 years that it's plaintiff's burden to show not only that the charges are reasonable, that they're customary. And even if there is testimony from Dr. El Tahawi about his $100 bill, there's zero testimony from Physiatry and Rehab or Capital Surgery Center regarding any of their bills, whether what the balance is, whether it's reasonable, and whether the charges are customary. Thank you, Your Honors.
Thank you.
Thank you. Thank you both for appearing. This matter is submitted for decision.
Thank you.
Next matter is docket 19, case number 369972, Trailer Express versus LWJ Trucking.
May it please the court. My name is Augustine Igwe, and I represent the appellant, National Transportation Associates. Your Honor, this case and the facts are pretty straightforward. I'm not going to repeat that, but an owner of an equipment listed to the appellees to use in their trucking business was damaged. And I represent the independent insurance agency, National Transportation Associates. In this case, there was a claim that my client failed to insure the vehicle as instructed. The original owner of the equipment, Trailer Express, received a judgment against the appellee for number one, failing to insure the vehicle, and number two, for failing to pay rental premium, rental payments on the equipment. We went to a jury trial, a bench trial. The judge found against my client. We are raising three issues for the on this appellate court. Number one is the court found against my client, but failed to take into account comparative negligence. Number one, the appellee failed to read the insurance policy because the policy would have clearly indicated that there was no coverage on this vehicle, on this trailer. There was a prior policy, which was through Lancer Insurance Company, which was non-renewed because of adverse loss experience. Then there was a new policy placed with Canal Insurance. And during that transition, the equipment was not included in the new policy. Because of a conversation my client had with the owner, with the lessee, not to include that because he was not hauling refrigerated goods at the time. Anyway, he disputed that and the case went into trial. The judge failed to take into account comparative negligence because he would have shown clearly that that equipment was not included in the list of covered items in the policy that was given to my client, to the appellees, and they would have simply saw that. They failed to read the policy. But most importantly, the owner of the equipment, Trailer Express, knew there was no coverage on that equipment before the loss happened.
So
Because
what legal duty would they owe to tell the other parties that there was no coverage? Where do you find the basis for a legal duty there?
I'm sorry, for the.
So you're essentially saying that Express should have told appellees that there was no insurance on this truck, right?
Correct.
So you're saying they had a legal duty to do that?
Not necessarily a legal duty, but no.
Well, that's important. So they did not have a legal duty.
Well, they did not have a legal duty,
That
but
means they
there
can't be
was.
comparatively negligent then.
No, but the point is, they knew about that situation. They inquired from my client about that situation, and they were directly told that there was no coverage based on instructions from the appellee. So those specific facts created a duty at that point because they were specifically told there was no coverage. Go and inquire with the appellee, and they failed to do that.
Sure. What is your legal authority for that?
Well, I don't have a legal authority on this point, but I'm just saying, based on the totality of the facts and circumstances, there was clearly the issue that there was knowledge that from the owner that there was no coverage, and they failed to follow through. A simple question: if they had simply told my client, yes, go ahead and put the coverage on this, and we'll inquire with Mr. Lawrence about this, then the situation would have been resolved. But it wasn't done. So there's a question of that knowledge, and they failed to do anything about it. Number two is that the appellee did not read the policy. The faxes that were sent, the policy that was sent specifically did not include that information. And they failed to follow, they failed to read it. A simple reading would have shown that. That's number one. Also, the trial court found that the appellee reasonably did not believe that there was a new policy, which is contradicted by every evidence in the file. Number one, he knew there was a new policy because they discussed that with the representative of my client, and they were specifically told that there's a new policy. The old one was non-renewed because of adverse loss development, and they failed to follow through with that. And so that's the issue of the comparative negligence. The other issue was the trial judge committed error because in the calculation of the damages, the original lawsuit was for failure to procure insurance on the vehicle and for not paying rental, fees on the vehicle. But when the trial judge granted judgment to the appellee, they included that. There's no reason to hold my client responsible for the appellee's failure to pay premium on the rented equipment. So the whole calculation of damages was wrong. And number three is that it's based on insufficiency of evidence. There simply was not enough evidence in the record for the judge to find the way he found. He relied, number one, on the fact that an email that was sent that enclosed the new policy referred to a renewal. This was a form that was just said, okay, here's your renewal that's used for a client that was, had a new policy issued. So number two was that during the trial testimony, my client kept, referring to when the policy was renewed. Therefore, the judge inferred that they reasonably believed that that was a renewal. Again, this is a term that they use in the industry, because even if the trial exhibit showed that the client testified when we renewed him, he had to go to a new policy. So that's the form they use. It doesn't mean a renewal in the legal sense of the word. It's just a renewal for a client whose policy has expired and they want to put him into a new policy. So for those reasons, I believe there was no sufficiency of evidence to support the ruling that the judge did. Thank you.
Do you have time for rebuttal?
All right.
Good morning. Attorney Louise Johnson on behalf of LWJ Trucking. In large part, unless you have questions, I'm relying on my appeal brief in response to appellate's oral argument. I apologize. I have limited hearing and I heard much of what he said, but I think for what I caught, I would rely on the brief. And unless you have questions,
Any
I'd be
questions?
glad to answer.
No question.
No, I
Thank
think
you.
we're all set.
Thank you so much.
Thank you.
And is it me or is it chilly in here?
It's cold. It's cold. I'm very comfortable. I'm cold. Thank you both for
Thank you.
appearing. This matter is submitted for decision and we will take a short break now. We'll now begin the 11 o'clock call. The first matter is item 20, case number 369-462, Brenda Miller versus the estate of Mardell Williams. And I believe we have two parties appearing remotely. There's Mr. Shotwell
Good morning, Your Honors.
Morning.
and Mr. Putney. Yeah, okay.
Good morning, Your Honors. Bradley Putney for the personal representative, Melissa Williams. May it
All right.
please the court.
Right, you may proceed.
Thank you, Your Honors. Your Honors, I would like to first address that the estate has not waived its right to appeal. There was a final order granting attorney fees on behalf of the defendant, and that is what's being appealed today, is the granting of those attorney fees, which is concerning the DD case number. The court made very clear in its opinion that in this CZ case for unjust enrichment, that it was a final order and directly appealable to the Court of Appeals, and the court stated, "Yup, make it a final order." And Mr. Shotwell, "That's fine." So, Your Honors, the DD case concerning M.E. as a developmentally disabled person, attorney fees to Brenda Miller was held in abeyance and required that if additional funds became available, that then she could petition the court for attorney fees. Ms. Miller did not do that. In fact, 6 months passed and the DD case was closed twice without Ms. Miller making a claim for attorney fees. It was closed first, not making a claim. Then, for some reason, she convinced the bank to return all funds to her, in which I had to file yet another motion. And the court ordered for a second time for all funds to be returned to the estate of Mardell Williams, the DE case. In all that time, Brenda Miller sat silent and she did not petition the court for attorney fees on either case. On either time, the court closed the case, the DD case. Ms. Miller had that opportunity, and her excuse that I did not have time or I forgot is an admission that she should have done so. So whether the court terms it as res judicata, waiver, or collateral estoppel, the issue is essentially the same. She slept on her rights and she did not make the claim and did not make the claim and the proper case number, the DD case number. It was closed by the court, checking box, I believe it's 9 of the order, closing the state and then discharging her as a fiduciary. So her claim that once the disabled individual died, she lacked authority is without merit. The authority is over the person. However, she still was in charge of money, did the final accountings, and did not submit her claim that was held in abeyance in those final accountings. So therefore, they're waived, res judicata and or collateral estoppel. The court's claim that, quote, in this court's view, in this case, a res judicata does not apply because Ms. Miller is in the position of any other creditor. I just simply cannot understand that and how it is even relevant to any issue of res judicata. So that is the essential basis of the case. Preclusive effect by that order. Latches, the only claim they sued in the CZ case is unjust enrichment, which is an equitable claim, and therefore the doctrine of latches also applies. And simply put, the court does not aid those that do not act in vigilance, which she did not make a timely claim, let alone a claim in the correct case number, and instead files a separate suit in CZ to attempt to make a claim in a DE decedent's estate case. Now, if you take the plaintiff's, Ms. Miller's claim that the court in DE case number would have concurrent jurisdiction, what that would mean then is in our wrongful death suit, any case that exists concerning an estate, a wrongful death case then would The probate court would have concurrent jurisdiction to hear that, and our probate courts would be flooded with wrongful death cases. That is not the situation. The court of general jurisdiction is the circuit court. The only claim made is an equitable claim, CZ, that belonged in the circuit court. The wrongful death case was filed. They did not file a counterclaim in the wrongful death suit, which would have been the court of jurisdiction and required by mandatory joinder. Ms. Miller never addressed the issue concerning unclean hands, concerning taking the money back from the estate, converting it into her account for a good 3 months without making the claim in the DD case, and never addressed our issue pled concerning that our defense of the CZ case was one in the same as that of the wrongful death case, our claims made in that, and therefore joinder would have been proper. Under 2.116G4, therefore, those are admitted, and our motion for summary disposition likewise should have been granted for those reasons. Your Honor, the claim of the CZ case is so frivolous that the court also should have granted costs and attorney fees. And I therefore request that the circuit court be reversed concerning the granting of attorney fees in the DE case concerning something based in the DD case that was closed, that had preclusive effect, that was a final order, and that actual costs and attorney fees be assessed. I would reserve the remaining time, which I don't expect to be my whole remaining time, for rebuttal. And I do welcome any questions of the court. Thank you for
Any
your time.
questions? Nope.
No
Okay,
questions.
thank
Thank
you.
you.
Mr. Shotwell?
Good morning. Andrew Shotwell appearing on behalf of appellee Brenda Miller. I just want to start by appellant has argued, is not arguing about the reasonableness or the nature of the attorney fees incurred, only that Ms. Miller somehow could have only brought her request for attorney fees in the guardianship matter or an unrelated case in another county that the estate brought. Ms. Miller was the court-appointed professional guardian of Ms. Williams, and lost in all of appellant's voluminous pleadings is that Ms. Miller took extraordinary steps to protect her ward and went out of pocket paying attorney fees for representation in her role as guardian. And this matter originated out of that claim. To believe that the sole avenue for Ms. Miller to recoup the out-of-pocket expenses was in the guardianship matter. It doesn't make sense. The court, while in that order of December 21st of 2021, the court did say that they were holding in abeyance. Ms. Miller was reimbursed for out-of-pocket expenses that she paid for creation of the special needs trust, and the court did say that they're holding in abeyance the remainder of that of her invoices, which was the $6,700 at issue here. That Ms. Miller never slept on her rights. I mean, all appellants raised judicata, collateral estoppel, waiver right. I mean, they're all very similar arguments that Ms. Miller somehow slept on her rights. She was transparent through the whole process. Just looking at the timeline, she received the inheritance that was discussed in that previous order on April 22nd of 2022 while she was the guardian. May 16th, a little more than 2 weeks later, Miss Williams passed away. And so Miss Miller, as the guardian, believed it the proper course of action to wait for an estate to open up and make a claim that way. She sent a letter to all the interested parties telling them that that's what she intended to do. The estate was opened. The estate has a process for processing claims. which this court is aware of through the EPIC procedures. And that's exactly what she did. The notice to creditors was published on July 6th of 2022. Within that 4-month time frame, Ms. Miller properly submitted a statement and proof of claim. That claim was disallowed, and she had 63 days to file a complaint, which is exactly what she did. So, I think that the res judicata, looking at that, that requires a prior action. The guardianship is not an action. It's a proceeding to protect an individual. It's not a lawsuit. There were no previously pled causes of action. So res judicata, the standards are not met for the elements of res judicata are not met. The prior action was never decided on the merits. In fact, the judge said, "I'm going to hold this in abeyance until an inheritance is received." And so those arguments are without merit, Your Honors, and that's what the lower court agreed with that assessment. That's why the judge denied their motion for summary disposition and granted my motion for summary disposition in part. Certainly happy to answer any questions on any particular issues, Your Honors, that you may have.
Any questions?
No,
Okay, we don't have any questions. Thank you.
thank you.
Any rebuttal?
Very short, Your Honors. The issue of attorney fees was held in abeyance in the DD case number. That case number remained open for over 6 months after death, in which Brenda Miller had control of those funds twice for 6 months, and never, as instructed by the court in the DD case, if she came into additional funds such as the inheritance, to then come back to the court with a petition, and he would then consider attorney fees for other attorney fees other than the special needs trust. She never did so, despite being the fiduciary and despite not being discharged until the order is entered compelling her to return the funds and fully discharging her as fiduciary for the second time. As to the CZ case concerning the only claim of equity, I would ask, what benefit did Mardell Williams receive by the representation of Diana Huff, who represented Brenda Williams? And what benefit is she keeping then by not returning funds to Brenda Miller? The answer is clear in review of Exhibit 3. Nothing. Thank you.
All right. Anything further?
No.
No. Okay. Thank you both for appearing.
Thank you.
This matter is submitted.
Thank you, Your Honors.
Thank you very much.
The next case is docket 21, case number 376488, Robert Weber versus Annette Weiler. We have two people that are endorsed for remote oral argument.
Message earlier to see if they were in the waiting.
Okay. May not be there.
So they were there before and then they're not there now.
Well, hey, judges, I'm trying. Yep, she's coming in right now. She should be.
Thank you.
I don't necessarily disagree.
Miss Weiler, this is the Zoom host. You have to accept the promotion if you want to come in to speak. And you should be prompted right now. Judges, she keeps declining the promotion.
Okay.
So
Can you explain to her what that means?
Yeah, Miss Weiler, when I'm bringing you in in order to speak to the panel, you have to accept the promotion on your screen in the affirmative, whether it says okay or, yep, here you go. She's coming in now.
Can you hear me?
Yes.
I am Annette Renee Weiler. I go by Renee Weiler. I am the appellant. Can you hear?
Yes, we can hear you. We can't see you, but we can hear you.
Okay, that's fine.
Can I-
Go ahead.
And there's also Stacy Weiler, who's endorsed for oral argument.
No, he's not.
He
He's
won't
not
be
here.
speaking. Okay,
Won't be speaking.
all right. You may proceed.
My name is Annette Renee Weiler. I go by Renee Weiler. I'm the owner of the Weiler Mortgage Group. And I'm entrusting your honors with what I believe to be a national security threat posed by fictitious entities. In this case, the Bank of New York Mellon trustee was suspended by the Federal Housing Finance Agency. This entity granted Mr. Weber his counterfeit deed using the corporate identity of Weiler Mortgage Group. Now, Magistrate Kevin Arthur Elsenheimer knew about the fictitious entity that was suspended by the FHFA in November of 2023. He has been involved in this case since 2018, and he allowed for the Japanese servicer Bayview Asset Management, Bayview Loan Servicing, a Japanese entity, to seize my property. And he knew that they did not have beneficial interest. Also involved in that case was Select Portfolio Servicing, owned by Credit Suisse or Suisse, located in the Grand Cayman Islands. So I protested vehemently about these entities seizing my property. I also reported it to the Leelanau County Sheriff's Office, and Under Sheriff Kiesel told me, per the phone conversation, that the county was too conflicted to investigate the matter. The case is now before this D crimes and the securitization fraud tax evasion scheme is now before Colonel Grady of the Michigan State Police. He has been non-responsive. I have asked this court to release the Attorney General of Michigan, State of Michigan, and the Department of Insurance and Financial Services any and all records related to the D crime on this property and others, and the counterfeit promissory notes that are being created by mortgage electronic registration systems. You will see my audits filed in this case under Exhibit C and D. Those are the audits that I did on documenting counterfeit promissory notes and mortgages with Special Agent Ed Martin of the U.S. Department of Justice. So the evidence is overwhelming that foreign entities are entering into our property rights, just like the Somalians in Minnesota. We have the same fraud going on within the MERS system. Now, this case, there is several cases Weber versus Weiler is in the probate case 21-10757-PH. This is a case where exculpatory evidence that was filed as an exhibit by Robert Kyler Weber was never docketed by Stephen Picara, the probate judge. So that prejudices me. That put me on the Michigan lien list, LEIN. I cannot work in the financial industry anymore. I've had to take a early retirement at 62 with Social Security to make ends meet because I cannot work because of the false claim made by Robert Kyler Weber. He had constructive notice through 2 affidavits filed in the land records in Leelanau County, and he chose to ignore that, banking on the fact that he could rely on the judiciary to uphold his rights to be granted a deed from the fictitious entity, the Bank of New York Mellon trustee. This case is also being included in another case in Kentucky where I am fighting against third parties who are claiming to be heirs. The case is Boggs versus Truby, case number 6:26-CI-00099, where I am fighting a county, Leslie County, Kentucky, to sell a 500-acre mountain in Appalachia that my great-grandfather granted me. And I will fight tooth and nail to stop any county from continuing to take my property, to seize my property without due process, without any legal or lawful authority, in violation of my constitutional rights under the Fifth Amendment and the 14th Amendment, as well as the First Amendment, because I have been muted by magistrate judges because I revealed the secret tri-party agreements between the government, Fannie Mae, and state bar attorneys in the taking of our lands. So everyone knows, even the Supreme Court Justice, the new one, her name is escaping me.
Justice Jackson?
Justice Jackson, who looked at that tri-party agreement and dismissed it. This is a case that went to the Massachusetts Supreme Court, and our judiciary is ignoring this. So the problem I have is I have exculpatory evidence in the probate court. There is a 4-inch binder where he knows, the plaintiff, Mr. Robert Kyler Weber, knows about the title abstract that was forged and fabricated by title abstractor Taylor Claire Lewis. And this goes to the national security threat that we have the largest title insurance company, Fidelity National Financial, omitting fraudulent mortgage assignments filed by state bar attorneys to insure over fraud. So this judge, or magistrate as he calls himself, Kevin Elsenheimer, knew about that. It was filed in the case. It was from a subpoena by 86th District Judge Robert Cooney. He gave me the subpoena to get all the information from Fidelity National Financial, who has had a catastrophic data breach. And my identity and my corporate identity has been used in multiple states. Ohio, someone decided they could be the vice president of Weiler Mortgage Group to transfer and assign a $400,000 property. So we're talking about Ohio, Michigan, and Kentucky. In Kentucky, we have the Bank of New York Mellon trustee involved in the securitization of mining contracts. I have not seen any of my mining royalties in 20 years, yet this property has been mined for decades. Nobody can tell us who's mining the property, but the Bank of New York Mellon trustee is associated with Greylock Energy and Arc Light. So we have massive fraud in our property rights. And I will stand by the Exhibit C and Exhibit D that I gave Special Agent Ed Martin. I also want to inform you that I have a whistleblower complaint, an award that is pending with the Commodities Futures Trading Commission involving the Bank of New York Mellon. So I will need any FOIAs that I have requested, including the FOIA from the Michigan Department of Insurance and Financial Services, Weiler versus MERS. The number is CP 2020-0291061-A. I will need that for my whistleblower award. I will also need that for the Washington, D.C. District case Powers versus Orange County District Attorney Todd Spitzer, because I'm an interested party in that one. There will be I've been told there's going to be a Key Tom case with 7 whistleblowers, including myself and Ms. Powers, who is a former title curator. Her home was stolen by Ukrainian national Mikhail Trubchik using the Bank of New York Mellon trustee at the fictitious entity to steal her ranch. Also involved is Fonnie Willis, prosecutor in Fulton County. I gave her all the information regarding Won Suk Seo, who is an Asian person, I believe a woman, who is claiming deeds of Janet Hill, the defrauded homeowner, and Jason Hines. She says she got her beneficial interest from the fictitious entity that was suspended by the FHFA, the Bank of New York Mellon trustee. Thank you very much.
Okay, any questions? All right, thank you. This matter will be submitted for decision. The next matter is docket number 22, case number 370102, in re contempt of Michelle Alowski. I believe she has not checked in. Is that correct? All right. I just said one case number, right? There's 2 case numbers. 370387 is also being called. Both matters are submitted for decision. Thank you. Okay, next case is number 24, case number 376895, Henry Turner, Wanzer Miners. Believe you are Madison Crumans?
Yes, Your Honor. My name is Madison Crumans. I'm a law student. I'll be representing the appellant mother, Meisha Wenzer.
Okay, you may
Welcome.
proceed.
Thank you. This case is one where everyone agreed that the best solution for the care of these children was the children's Aunt Inez. However, the trial court failed to appreciate that this was an appropriate mechanism to resolve this case along every step of the way, at removal, at adjudication, and ultimately at termination. With the court's permission, I would like to focus on adjudication and termination, although we have briefed all three of these issues.
That's fine.
To begin with adjudication really emphasized the errors that occurred during removal and made them even more obvious. This is because the trial court found two grounds under MCL 712A to B1, and these were both incorrect findings. First, the children did not have no proper care or guardianship.
The guardianship, though, it expired, I thought, by the time they got to adjudication. So the aunt didn't have any way to have these children to get them medical care, to sign them up for school, anything else, correct?
Your Honor, at the beginning of the case, at the removal stage and at adjudication, there had been active powers of attorney that the mother had signed.
But then she reneged them. She retracted them.
She had revoked them in the past after Inez had taken care of the children, and then she had taken care of them again. The mother had resumed care of the children. But at the time of removal, the powers of attorney were actually active. The problem was at removal stage was that for some reason, Tennessee was not recognizing them. DHS was never able to write or document why this was the case. And this is the main problem here. For removal, reasonable efforts weren't made because DHS didn't try to make sure that those powers of attorney could allow Inez to take care of these children.
Okay, so you're asking the Michigan Department of Health and Human Services to control something that happens in Tennessee. And that is essentially an impossibility. They have to go through the ICPC, and that takes time. And the aunt did whatever she could to come up here, I think 2 or 3 times to watch the kids. Then mom would get out of her facility, take the kids back. Aunt would go back to Tennessee. And there's no way that DHHS could have done anything to make the Tennessee courts recognize, realize, grant the guardianship, recognize the guardianship papers or anything else, because it's a whole separate state. There's no obligation for them to do anything.
I agree, Your Honor. There's nothing, well, there is things that could be done, though. There's no way that Michigan could tell Tennessee, you have to recognize this power of attorney, but there's other ways that this could have been done. And in the case of Matter of Curry in 1982, this court said that something like signed papers to allow for enrollment in school would be an appropriate situation here, and rejected the contention that children had to be made temporary wards of the court in order for medical care or school care to be accessed. Here, the ICPC was only needed after removal. So the children could have been taken care of by Inez, and that would have avoided removal in the first place, but also adjudication.
So I don't understand. So you're saying that the mom could have signed a paper that said, you're not the guardian, you don't have a power of attorney, but I'm going to let you enroll my kids in Tennessee in school?
The powers of attorney were active, however, Your Honor, that there were powers of attorney, and that was what the mother and Inez both intended and believed to be a guardianship here. And it obviously was not recognized by the trial court, but after removal happened, the court said, even if reunification doesn't end up happening here, the result could always be a legal guardianship. That is always an option. That was said in June of 2022. So when adjudication happened and the trial court did not recognize that there was proper care and guardianship through Inez, and at the termination stage, where the trial court did not acknowledge or weigh a relative placement against termination, that is where the error occurred.
But they don't have to. I mean, it says that it can weigh against termination, right? So, but the aunt, Inez, is it?
Yes.
Thank you. Aunt Inez said she didn't want a guardianship. These were very young children when this case started out. DHHS would never have approved a juvenile guardianship for this case because the children were, 2 of them were, I think, 15 months and under. And then the other ones were like 9, 7, and 5 or something along those lines. But these are very, very young children. So to say that just because they were placed with a relative, it's error to say that termination is in their best interest goes way too far afield.
Well, Your Honor, there's the Mason requirement that the court must consider a relative placement and weigh it against termination. There's also in the best interest analysis, the requirement from In re JMG from the Michigan Supreme Court 2025, that the analysis here is whether retaining the parent-child bond is in some way beneficial to keep. And that is
the bond had really waned. The mother wasn't taking advantage of her visitation, probably because of her mental health issues. And I mean, that was the evidence that came in, correct?
There's a lot of evidence in this case. Yes, it's undisputed that the mother had some mental health concerns, but there's an evidence that the children did have a bond with their mother that would have been beneficial to preserve, and guardianship would have allowed that to be preserved.
But the bond, it waned, didn't it? Because I think the older children, maybe the second oldest, I can't remember the initials, and I apologize. It's just, this is the second day of our case call. That they were upset about by the mother's activities, by the things she would do at visitation, and they didn't want to spend time with her after a while. So there may have been a bond at the beginning, but because they were removed so many times and so much was going on and mother wasn't getting better, that bond was extremely weakened by the time we got to termination. I mean, they waited a long time. They gave mom a lot of time to get herself together and to get her mental health together and get the resources she needed to support herself and her kids. But it didn't exist by the time they got there.
Your Honor, this case did go on for a long time. It was about 3 years. And what we are saying is that because removal had its errors and because adjudication had its errors, it did not have to go on for this long. It didn't have to get to the point of termination where the bond had waned a little bit. It's true, but the analysis is not whether the bond was perfect between these children and their mother. The bond, it's whether there is some sort of bond there that is worth preserving in a way and not terminating. And because of there was some evidence of the bond that these children had with their mother that was noted as late as January of 2024, where DHS noted that there was appropriate parenting skills, that she showed love and support towards her children, and that the children missed her. And also that there was a guardian who was willing and able to be a guardian who preferred guardianship until the very end, when this fatigue of the case going on for so long meant that she changed her goal to adoption, as DHHS noted, to keep it out of court, to finally get things out of court. But in that same documentation of that call where Inez changed her goal, she also stated that she never wanted to keep the children away from their mom. And that is the fundamental error here in the best interest analysis.
But in the best interest analysis, also, mom moved to Minnesota. So she could have moved from Michigan to Tennessee to be by her kids. And it's very hard when we place kids out of state in order to preserve any sort of visitation. They tried in-person visitation. It didn't go very well. They tried video calls and chats and phone calls and things like that. But then mom moved further away from Tennessee. I'm having a really hard time to acknowledge that somehow there was a relationship that needed to be preserved, given the number of times these children had been removed from their mother, her mental health problems, the fact that Inez was keeping these kids safe and had them there. The older kids didn't want to have a continued relationship. It was extremely strained. They were uncomfortable with what mom was doing, right? And like I said, I could go back and try to find it, but I thought that there was testimony at the very beginning that the power of attorney or whatever mom and Aunt Inez had lapsed by the time that all of this started. So there wasn't proper care and custody.
I'd like to address multiple pieces of that. First, with the powers of attorney, there had been a lapse in that, but they had signed a new one while Ms. Wanzer was in the mental facility. She had signed new ones for the care of these children. DHHS.
Do you think that's sufficient if someone is in a facility for mental health issues? Would that be enforceable, that she was competent, knowing, voluntarily and understandingly signing something when she's in inpatient mental health care?
She had been recovered. It wasn't immediately when she was admitted into the facilities, and it was after conversations. The powers of attorney were something that was suggested by a former guardian ad litem in a case. DHS is approved for Inez to bring the children to Tennessee with those powers of attorney, which I think is the most important piece here. It was only until there were some snafus with that and Tennessee supposedly not acknowledging those that it became an issue and removal and then adjudication happened based off of
Can
it.
you flesh that out? I know in your brief it says Tennessee said the power of attorney was inadequate. Why? Why was it inadequate?
Throughout the case record, there is no explanation of this. And from a brief search of Tennessee statutes, I was not able to find any place that says that it would not be active between states. DHHS never explains it in their case service records, in their communication records, just says that they spoke to Tennessee staff and Tennessee staff at the court said it's not going to be active. But in our contention, that's not reasonable efforts. That's not looking into what other options there could be, including maybe virtual signing of papers, perhaps just trying a little bit more than 4 days to make sure that removal didn't have to happen in the first place. And there had to be 3 years of state involvement in this family that had a care plan in place. Not only was there Inez available to drive up from Tennessee to take care of the children, she would take care of them in Michigan and if necessary, bring them back to Tennessee. But there was also relatives in Battle Creek that took care of the children in the interim. And so this was an appropriate family safety plan that should have been acknowledged and appreciated here. In Ray Dixon, this court said in 2023 that if a parent places a child in the care of a relative whose home is not unfit, and DHHS supported Inez's ability to take care of these children, then the language of without proper custody or guardianship language in adjudication is not satisfied.
I agree. Do you believe that the case would have turned out completely differently if Inez had moved to Michigan and lived in Michigan?
So Inez had work, she had a job in Tennessee. And so it was important for her to remain there at the time. To address your earlier question, Your Honor, Ms. Wanzer moved to Minnesota in order to be able to have better access to services that would allow her to eventually take care of the children. So while she was there, she had therapy. She received housing that would have fit all of her children. She eventually lost that because of the ICPC denials that happened. And that the ICPC denials from Minnesota, I'm not able to tell you why there was repeated denial. There's 2 denials, but the denials like that led to the administrative fatigue that culminated in Inez finally throwing her hands up and saying, it's okay, well, okay, I'll do adoption just to get this out of court. That was the family's main concern. They wanted this to end.
Do you think that the court actually just said, okay, we're going to do adoption to get this out of court?
Your Honor, yes, there was an acknowledgement that the family wanted this to be out of court, but guardianship would have been an appropriate way to resolve this as well.
But it wouldn't have been permanent for the very young children who had gone through practically all of their life, all of their young life being out of the care of their mother, correct?
Guardianship would have provided an appropriate amount of finality and stability. It's in the statute itself that guardianship may continue until the child is emancipated.
But yeah, but what happens if Aunt Inez gets sick? So she can't care for the kids anymore. Then they go to the people in Battle Creek, and then they go to somebody else, and then they go to somebody else. Or mom files for ending the guardianship. It goes back to mom, and they have to come back again because mom's mental health isn't taken care of. Guardianship is a way to try to address things on the short term, but for very young children, all the studies and everything else show that they're contrary to stability for very young children, because you don't know where you're going to be for 18 years, really?
Your Honor, I'm not able to recall the exact name of the case, but I believe there is doctrine from this court and the Michigan Supreme Court that says that young age is not it cannot be the sole factor in determining that guardianship is not appropriate for the children. So
I agree, but still, I mean, the case was complicated by the fact that mom left to go to a third state when Michigan and Tennessee were trying to work things out.
she did. She also, at one point in the case, and I can pull it here, in January 2025, Ms. Wanzer lost her Section 8 housing that would have held all of her children in Minnesota. And when she asked DHHS if she should move back to Michigan in order to expedite the return of her children, DHHS advised her against it. they said she should continue to access her services in Minnesota. And this is documented in DHHS's communication reports. So the multiple states going on here, Ms. Wanzer tried to rectify that by suggesting that she move back to Michigan. DHHS turned that down. And a couple months later, we get to termination, in which it's DHHS uses it against her that she was in Minnesota and not in Michigan or Tennessee, when she had offered to change that situation.
But she already had services set up, so why change something that would make her have to restart services all over again? I mean,
Because
she made the decision to go to Minnesota, so you're just talking about the decision to come back.
It was because of the ICPC denials that were causing a lot of issues here, that were causing a lot of, again, administrative fatigue here, that made the family tired, that made the court tired, that made DHHS tired.
I'm going to take issue with you assuming that people get tired in these cases. They go on for a very long time, but lots of times we hold these cases because we want to provide additional services to people. And tiredness has nothing to do with it. I had cases that went on for 10 years that were neglect cases because we did what was best for the children. So to assume that DHHS was just getting tired, this was a case they had to handle. The court had to handle it. Mom had to handle it. Aunt Inez had to handle it. And I want to just guard against us making assumptions along those lines.
Of course, Your Honor. Mainly, the piece about the fatigue here is that beginning October of 2024, DHHS started to have conversations with Inez, although she had consistently stated that she preferred guardianship and that she did not want to keep the children away from their mother. The DHHS conversations kept happening until finally in June of 2025, she changed her goal to adoption. And this is what ultimately led to the termination hearing and the adoption proceedings that happened immediately after. These conversations only emerged after the second ICPC denial with Minnesota. These conversations, again, October 2024 until the following year. And this is contrastable and distinguishable from cases that this court has heard where relatives did not want parents to be involved. Inez wanted Ms. Wanzer to be involved in her children's lives. In Ray Gonzalez-Martinez in 2015, this court found that guardianship was appropriately rejected because relative placement didn't feel safe around the parent. And in Ray Walker-Hughes, which the DHHS actually cited in their termination recommendation, in 2023, the relative placement wanted full control over when the children saw the parent. That was not the case here. That was a place where guardianship might not have worked for the family, but because Inez stated in the conversation where she said she changed her goal to adoption, that she never wanted to keep the mom away from her children, and that's a quote, never keep mom away from her children, guardianship was an appropriate result here, that it would have provided the resolution that this family needed without going to the point of completely severing the relationship between mom and child here.
All right, I think you've just about come up to your 15 minutes.
Yes, thank you.
Right,
Thank you very much. You did a very
Thank
fine
you.
job.
very nice. Yeah.
Appreciate it.
Where are you in school? Where are you going to school?
What year? Very good. Excellent.
Best of luck.
Thank you so much.
Yeah.
Come back
Yeah,
again.
Best of luck to you.
Hey, Judges, it's the clerk's office again. Sorry for the interruption, but for item 22, Michelle Olowski was granted remote argument. I just failed to make the update, so it did not show up on your list, and she is in the gallery.
So, yeah. They forgot to update the sheet,
Okay,
Yeah. Oh, yeah, that's her.
all right then.
That
We
was
will-
our mistake.
We will, yeah, we did not have that information. So we will go back to 22, docket 22, case number 370102 and case 370387 in re contempt of Michelle Olowski. All that matter.
Can you hear me all right?
Yes, please state your name for the record.
Michelle Olowski, whose heart is beating very fast right now. When you guys skipped over, I was scared.
Sorry about that. We didn't have that information. So it's
I
our
understand.
fault. So,
Well, I'm glad you had
go ahead.
a helpline that I could call quickly and get it resolved. Um, so may it please the court, thank you for allowing me to speak with you today regarding this issue. As I said, my name is Michelle Olowski. I am a former attorney and subject to both of these contempt proceedings before the court today. The issues before the court today are what I believe were improper uses of the contempt powers of the Alpena County Probate Judge, Alan M. Curtis, and his failure to follow the proper procedures that have been clearly set forth by this court and the Michigan Supreme Court regarding contempt proceedings. Before I get too far into my arguments in this case, for background purposes, I believe it's important for the court to know that I have a documented chronic long-term medical condition that began in May of 2012. In fact, the very first time I started having issues, I was practicing law in Kent County, and the first time I ever had to request an adjournment of a hearing due to my medical condition was with Honorable Judge Feeney. I recall as a young attorney being so stressed to make that call and feeling so much better when the court understood and the clerk understood. Since 2012, I've had 4 surgeries to try to resolve my medical issues, including a colostomy bag, removal of my colon, a sigmoid colon, removal of over a foot of my intestines, and numerous other medical procedures. Due to all these surgeries, I have internal scar tissue that are called adhesions that without warning wrap around my internal organs and intestines, causing me severe pain and numerous blockages in my intestines and a host of many other issues. In his surgical notes, the last surgeon that operated on me stated that the level of my internal scar tissue was so severe that the best way to describe it was vicious. Like external scarring, there's no cure for it. In fact, they can't even view it on any imaging, such as an MRI or a CT scan. But it can only be viewed by cutting me open again. And that unfortunately will cause more scar tissue to occur. I want to bring this up because that's kind of what happened on this day. I do want to make it clear that even prior to this date, even though I've had this chronic long-term medical condition, then in all the hearings that I have ever been in front of in various judges in Michigan before November 3rd, 2023, the date of this hearing, I had never once had to advise a court in open court that I could not represent a client because I was medically unable to do so. If I had a medical issue occur, I would find someone to cover the hearing for me or request an adjournment. In this case, the Honorable Alan M. Curtis was well aware of my chronic long-term medical condition, as he had covered cases for me in the past prior to becoming judge, and I had practiced in front of him frequently due to a contract I had with the County of Alpena for several years to provide legal representation for individuals with various mental health conditions. Unfortunately, due to the worsening of my condition, I had to resign from that position in late 2023. Due to the worsening of my condition, my medical provider had been making changes to my medication. Unfortunately, this meant an increase in change in pain medications I was taking. I went from taking hydrocodones to then them trying to put me on Oxycontin. My medical provider and pharmacist worked very hard to determine a dose that would not make me ill, but unfortunately, it did. After several attempts to find a dose that worked, we changed medications again, and now I'm taking morphine multiple times a day to manage my symptoms. I will also add that in the almost 10 years that I've been on this type of medications, I was always very careful not to take them just before I had court hearings or if I had to drive so that I would not affect my ability to do my job. While this meant quite often I had to practice in pain, I did not ever want to run the risk of it causing problems with my representation of my clients. In fact, knowing I had court today, I made sure not to take my medications so that they would not impact my arguments. Well,
Is there a reason to know why you didn't get back, even though you had to leave? Why you didn't get back on the line after you got sick?
Because I was that ill.
Okay, and did you tell the court that they could do whatever they wanted to? You were just going to leave?
I told the court that they would have to do what they needed to do.
Okay.
I did.
And
Yep, I did.
And throughout this case, I mean, so much of it was all about what happened to the money in the estate, right?
Well, that was what was the purpose of that hearing that day was actually regarding my clients. as trustee of the estate. That one necessarily did not have to do with me on that particular date. I was representing a client on that date.
Okay.
The one that occurred on March 14th, when the sentencing actually happened, that one was directly related to me. But the hearing where I was actually held in contempt on November 3rd, 2023, I was representing a client at that point in time.
But, and, you know, it's one of those sorts of things that, when, we have a situation, where people can't appear, and the court has to take action, that there were other things that your request happened right before the hearing. I understand all the medical things that are going on. And there was no way that you could do what you'd done in the past, which is get somebody to cover for you?
Not because of the nature of the proceedings that were going on that day. That was just not possible. If I could, can I continue or would you have more questions?
Go ahead.
Okay. On November 3rd, after yet another change in my medication due to my adverse reactions, I took the medication that morning, several hours prior to the court hearing in the afternoon. I know that typically is about 4-hour acting medication, so I felt comfortable being able to do so, especially because I knew that they had worked to lower the dose. Unfortunately, I had an adverse reaction. And due to the nature of the proceedings that were occurring that day, coverage was not an option, as I said. And I did advise the court and opposing counsel prior to the start of the hearing that day that I was having an issue due to the medication change, but I didn't receive a response. Because of the reaction that I was having, I was unable to drive, so I appeared via Zoom, which the notice that I had to appear indicated that was possible, and it provided the Zoom information. There's a lot of it that's fuzzy, but when I'm reviewing the transcript from the court, obviously you can see the court was not pleased with the issue that I was having. And I had made a request from my doctor to confirm what was going on. It just hadn't been received to the court by then. It was received to the court later that evening, but it did not come in before the court hearing happened that day. As the hearing progressed and the court questioned me regarding my position and why I felt that I could not provide legal services that day, I became increasingly sick and nauseated, and to the point that I needed to use the bathroom immediately. And instead of doing and just running away in front of everybody else on Zoom, I did tell the court to do what it needed to do, and I ended the call so I could address my needs. At that point in time, the court held me in direct contempt, but never indicated what the sentencing would be. The court felt that I left the hearing because I wasn't getting my way, when in reality I left because I was going to vomit. Had I been in person in court, I would have ran out of the courtroom in the same way. I know that's not the right way to handle things, but I didn't know any other way to handle it at that point in time when I was feeling the way that I was. I mean, I ended the meeting and I got sick, and I was sick for quite some time. Now, after this November date, I was in front of this court on this case on December 22nd, 2023, February 5th, 2024, and February 12th, 2024, without the court issuing any kind of sentence on this direct contempt. It was not until March 2024, over 4 months later, and after a contentious hearing in which the court was going to hold me in direct contempt if I refused to answer questions or invoked any of my legal rights, such as attorney-client privilege or the Fifth Amendment, my counsel at the time adamantly objected to the conduct and indicated to the court that I was entitled to have a hearing. The court refused to allow me to have any type of contempt hearing and sentenced me at that time to 45 days in jail. The court gave me 7 days to report, and during that time, I filed this emergency stay and motions and filed this appeal, and that's how we got here today. It's my position that I shouldn't have not been held in contempt of court that day based on the facts and circumstances. I was being honest with what was going on. I could not represent my client. I should not have ended it that way, but at the time I didn't know what else to do other than take care of the issue that I was having physically. And if contempt proceedings are necessary based on the case law that I provided in my brief, due to the delay from the finding of the contempt to the sentencing and the fact that the court in its very judgment of contempt indicated it was criminal contempt, I should have been allowed to have a full hearing with a different judge. As the court's aware, the contempt is a willful act, omission, or statement that tends to impair the court's authority or impedes its functioning. I recognize that day I impeded the court's functioning by getting off of Zoom because of what I had going on.
Ms. Olowski,
Yes.
with respect to having a hearing in front of a different judge, I believe that the judge found you in direct contempt. So that judge would have to be the one who would do it because all the information that he needed to find you in contempt was within his view and knowledge, correct?
Well, there's case law that indicates like People v. Kurtz, which was 35 Mishap 643, 657, 192, ND 2D 594 from 1971, that says that this court has clearly stated that in every case where a judge defers consideration of contempt citation, the charges must be considered and heard before another judge.
But you understand also the only reason he had to defer it was because you were on Zoom and you weren't there, so he couldn't do it immediately. I mean, I had people who swore at me in court. I would ask them to repeat what they said, and the one woman actually did. And so I was able to hold her in direct contempt. I gave her like 30 days, but held such and such in abeyance, and the deputies took her off. So that's typically the way direct contempt goes. But if somebody is on Zoom, you lose that ability, especially if they, you know, which I've also had happen where people get very brave and they say very nasty things and then turn their Zoom off. So again, direct contempt. I was the one who saw it. I was the one who heard it. I was the one who got to sentence them. And sometimes they refused to come into court because they didn't want to be sentenced. So the fact that I wasn't able to sentence them that day didn't make it improper, correct?
It didn't make it improper that you couldn't sentence them that day, but the way the case law is written, if we're getting into a criminal contempt, if there is a delay, then it kind of changes it a bit. And I also, in saying that, I was in front of him again in person on December 22nd, 2023, and he did not do anything with that contempt that day.
But I believe that he wanted to set it up for a separate hearing because you had all those other hearings, as I recall, and you can correct me if I'm wrong, because it's kind of late on their second day.
I understand.
Was that they were trying to find out what happened to the money. They kept asking you, where did the money go? You need to give us an accounting. What happened to the money? Where is the money? And you wouldn't give them the information that they kept seeking. And so there was other things that they were trying to get resolved, and he set it off for the date when you actually were sentenced. So you knew that that was the date that you were going to be sentenced, right?
No, not actually. That date was set as kind of a status conference date. We did not know that sentencing was actually going to occur on that day, if I recall correctly. All I've ever asked for is just to be able to have an actual hearing where I can show the court exactly what happened. In all of the times that I have ever practiced in front of this court or any court, I have never had to stand before a court and say, I cannot do this today. I cannot adequately represent my client because I am unable to do so. That was what I felt I was required to do. I understand the way that I left was not necessarily the right way, but under the circumstances I was going through at the time, I was having an adverse reaction to a very strong medication, and I wasn't my normal self. That's why I didn't handle it how I would normally have done and how I have done in my entire career is I've never walked away from something like that. I understand that the court has a purpose and there's things that we have to do. And I only handled it that way that day because of the circumstances that were going on. But the problem is when we had the hearing in March then, and we're telling the judge that we have, proof of what time I got that medication that day and all the things that have gone on, he indicated, well, that's the kind of evidence that, that you need to have. Well, it wasn't set for a hearing for that. And my attorney tried to explain that this is not what we were set for today, so we wouldn't have these things here. If I'm still found in contempt after actually seeing what I said happened that day, okay. But the problem is there's lots of inferences, like for some reason that I didn't want to be there that day. That's not the case. I've stood and had to face a lot of things, and I take responsibility for those things, and I'm paying the price for those things. But on these, during this time, that still, I've always been there. I've never not shown up. This is not normal, my normal courtroom behavior. And it was more, unfortunately, it felt more like a retaliation than it was an actual proper way to handle it. When we're talking about it being called a criminal contempt, I had certain rights that I should have been allowed. And I understand that it was delayed because I left Zoom that day. I completely understand that argument. But when I'm then in front of him another 3 times after that, and this doesn't come up until 4 months later, there's a lot of things that have changed and a lot of things that have happened. And I was not ever allowed to provide that to the court. And I think case law clearly indicates that's how it should have been handled.
All right, Ms. Solowski, it's been 15 minutes. So did you want to wrap it up, please?
Well, the other issue that was part of this case was whether or not, when I was being threatened with direct contempt for if I was to plead the fifth or if I was going to claim any kind of privilege, I was told in those court hearings, and the transcripts will show, that if I did either of those things, that I would be held in direct contempt and be taken directly to jail. I don't believe that was proper. I answered the questions because I didn't want to go to jail. But that was the threat, and the transcripts were pretty clear that if I invoked any of my constitutional rights, or even my rights as an attorney for privilege, that I would be held in direct contempt that day and incarcerated. So when I answered the questions, and against, obviously we objected to that, but I answered the questions and I answered them. That's when then the contempt came through from the November 3rd for the 45 days. So I understand there's a lot of things that have happened in my case and in me as an attorney, but I'm still afforded the same rights as it relates to my constitutional rights, or even being able to have a hearing to show that there was something medically going on, when I know that there's all documentation of it, and the courts have been provided numerous documentations of what was going on with my medical and my medical leave, so court hearings could be scheduled. So I hope that you can understand where my position is. I certainly understand yours, and just, if not, find it shouldn't have been direct contempt at all. That at least find that I was entitled to have a hearing on the matter, because it was considered to be a criminal contempt, and the due process rights that I'm supposed to be provided were not provided, and allow me to have a hearing with if the same judge, so be it, or a different judge, as the case law that I've read seems to indicate. Contempt powers are huge, and I just feel in this case that they weren't. The process in which it happened was not proper on my end, and also on the courts. And I think there's a way to fix this. And I think that if I'm allowed to provide the information, that it will show that what I said occurred on that day was what was occurring on that day.
All right, we understand your position, and we will consider your case, and it's submitted for review, and you'll hear from us soon.
All right.
Thank you.
I would just one more thing, if I could. Right now, currently there is that stay in place. If the court for to some reason not rule in my favor, and I wish to seek other review, I would just ask that stay remain in place until I'm allowed to do so.
All right, I'm not sure what we can do about that, but we'll look into it. Thank you.
Thank you.
I appreciate it. Thank you. Have a good day.
All right, the next matter is docket 25, case number 375355, Michael McCall versus WC Hockey. This case, there is no one endorsed, so it will be submitted for decision on the briefs, and that's the end of the call. Thank you.